Hi, everybody. This is Jerry Garrettson, Tabia Law. And God said, let the earth bring forth the living creature after his kind, cattle and creepeth thing, and beast of the earth after his kind, and it was so. We just had a case Supreme Court ruling, Sanchez versus Mayorkas, which we just had Secretary Mayorkas, head of the DHS, Department of Homeland Security, at our AILA conference. And it's an interesting talk. The case centers around Sanchez. I believe he was from Colombia. I could be mistaken on that. Came into this country as a TPS, temporary protected status, and that's given to those that come across the border from a scenario where they're being persecuted, almost like an asylum scenario. And so anyways, so he comes across, and the question was, now that he has a TPS, can he adjust later to get his green card? That's a question. He tried to adjust. I think he came across 2002 and tried to adjust in 2014, something like that. But when he tried to adjust, the court said no. And then we had several splits. The 11th and I think the 3rd district or circuit courts said no or yes. And then there's other courts that said yes, he can adjust his status from TPS, temporary protected status, to legal to get his green card. And so the Supreme Court ruled that no, he can't. With a TPS, that doesn't mean that he's admitted, right? And there's a question of being admitted, inspected, but the TPS doesn't quite bring someone beyond that threshold. So the Supreme Court just ruled a few days ago that no, if you have TPS, if you have that status, you cannot adjust, and you cannot file for your green card. Now, there may be other avenues, but it can't be an adjustment as far as the Supreme Court is concerned. So that's it for today, and we'll talk to you guys next time. Thank you.